So, good morning again. You're going to be sick of me by the end of this meeting. I just wanted to explain just a little bit more about who I am and what we do. As the global coordinator of the HIV Justice Network, we have been monitoring laws and HIV criminalization laws and prosecutions, as well as the growing movement, the growing advocacy and legal and policy movement against these laws and prosecutions for more than a decade. And in the last few years, thanks to the Robert Carr Civil Society Network Fund, we have now been able to expand our work and start the HIV Justice Worldwide Coalition, which is really making, we hope, is already making a huge difference in terms of what we're able to do on a global level. So in the next few minutes, I'm going to provide some definitions and a global overview of what we're describing as HIV criminalization. So HIV criminalization, in our definition, it describes the unjust application of the criminal or similar laws to people living with HIV based solely on our HIV status. And I say our because I'm living with HIV. I have been since 1985. Either via HIV-specific criminal statutes or by applying general criminal laws. And HIV criminalization is now recognized as a growing global phenomenon, but recently, it's only really recently that it's been given the attention it deserves, considering that it does, the impact that it has on the HIV response, undermining, of course, the UNAIDS fast-track goals to end the epidemic by 2030. And there is a growing body of evidence that HIV criminalization is also having a terrible negative impact on the human rights of people living with HIV, who of course are often also members of other key population groups. And this is due to selective and arbitrary investigations and prosecutions, the use of threats of allegations that trigger prosecutions as a means of abuse or retaliation against a current or former partner living with HIV, improper and insensitive police investigations, limited access to justice, including as a result of inadequately informed and competent legal representation. Of course, that excludes everybody in this room. Sentencing and penalties that are often vastly disproportionate to any potential or realized harm, and stigmatizing media reporting. Again, people in this room, I'm sure, are not guilty of this, that often includes names, addresses, and photographs of people with HIV, including those not yet found guilty of any crime, but merely subject to allegations. And this is, of course, a huge barrier to HIV prevention, treatment, and care. So, what are typical HIV criminalization laws? I'll be providing a global map soon so you'll see where they are and where the prosecutions are taking place. But most HIV-specific criminal laws are overly broad, too vague, and just don't reflect up-to-date understanding of HIV science. We'll be talking in tomorrow's session in much more detail with Professor Francois Venter about science and the implications it has in the context of criminal law. So these HIV criminalization laws usually single out HIV alone, which of course is inherently stigmatizing, can criminalize behavior that is not an HIV risk. These laws do not adequately define mens rea, state of mind, for those of you who don't speak Latin or who aren't lawyers. So what exactly is willful transmission, and how is that defined? And these laws often lead to disproportionately long sentencing including up to life imprisonment. So since 1998, there have been international guidelines on HIV, AIDS, and human rights. Since 2003, and then again in 2008 and to 2013, UNAIDS has produced more and more guidance and recommendations on this. And the Global Commission on HIV and the Law in 2012 also produced guidance on this, and they all do not recommend the use of HIV-specific criminal laws, instead recommending the use of general laws, but only for the most egregious behavior, i.e. the malicious, intentional transmission of HIV. So when I describe some of the typical HIV criminalization cases that we see from all over the world, including on this continent, most cases involve an HIV-positive person having sex where it's alleged that they did not disclose their HIV status before sex. The thing is that many of these cases involve the potential or the perceived exposure of HIV. There was no HIV transmission even alleged. Many of these cases include acts that pose no or negligible risk. For example, the use of a condom when someone has a low viral load, either on treatment or off treatment. When oral sex is the only sexual contact. And there's also been prosecutions for spitting, biting, scratching, and even breastfeeding. In many of these cases, there is a faulty assumption of guilt where transmission is alleged. For example, the first person diagnosed in a couple is often considered to be the first infected when we know that is not the case, not necessarily the case. And phylogenetics, which we'll discuss in much more detail tomorrow in the science session, which is the science of attempting to compare one strain of the virus to another, even when it is used, and it's very rarely used, even in countries where it's affordable and accessible, the results can really be misinterpreted. And in fact, amongst the thousands of known prosecutions, cases where it was proven beyond a reasonable doubt that an individual planned or wanted to infect another person with HIV are unusual and extremely rare. Some examples from around the world. In Canada, a woman with HIV with an undetectable viral load on treatment was prosecuted for aggravated sexual assault, which is the law that they use in Canada, for allowing a man to perform oral sex on her. In Malawi, and we'll hear much more about this, I'm sure, over the next few days, a woman on antiretroviral therapy was prosecuted for breastfeeding another woman's baby. In Russia, 2 women are currently under police investigation for not having prevented HIV transmission to their newborns. In Uganda, and we'll hear a lot more from Rosemary later today, a nurse living with HIV was vilified in the press and prosecuted following a needle stick injury. You'll hear later today from Kerry Thomas, this man from Idaho, had sex with a condom and had an undetectable viral load on treatment, but both of which would mean that there was absolutely no risk of exposure, never mind transmission. But he was unable to disclose his HIV status, and in that particular state, in Idaho, the law is a non-disclosure law. There was, of course, no transmission, but he was still sentenced to 30 years, and that's where he is right now in prison. And in Texas, a homeless man with HIV was prosecuted for simply spitting at a police officer during his arrest. That might be considered simple assault in the context of HIV. His saliva was considered to be a deadly weapon, and he was sentenced to prison for 35 years, and he remains there. The key issue is, of course, that too many people living with HIV are being convicted of crimes contrary to international guidelines on HIV and human rights, as well as contrary to scientific evidence, medical evidence, and the best public health advice. So I'm not sure how well these maps show up on the big screen, or certainly on the streaming stream, but you will be able to access these slides later. But this is showing you where, as of September 2017, we are aware of HIV-specific criminal laws. And you can see they're pretty much all over the world. The red on the map are the HIV-specific laws. Orange is a few countries with proposed laws. A few countries in the United States, in particular, you can see some yellow countries, yellow states there that have actually modernized their laws recently. So the term modernization is, in fact, is keeping the laws, but at least making them consistent with up-to-date science. And there are 68 countries, 98 jurisdictions if you include the 29 US states and territories with HIV-specific laws. If we look at actually where prosecutions have been taking place, you'll see that they have been taking place in many countries that don't have HIV-specific criminal laws, using general laws such as poisoning, bodily harm, sexual assault, as I mentioned in Canada, and even in a number of countries, attempted murder. I believe here in South Africa, that's how HIV has been prosecuted. And then not all countries with HIV-specific criminal laws appear to have applied them, or at least were not aware. But all of these data are based, of course, on our best knowledge, which tends to rely on media reporting or on contact with organizations working on HIV and human rights in the country. And as we're growing the movement, we're getting more and more detailed and robust data. But these should still be seen as tips of the iceberg rather than definitive numbers. So in terms of countries that have used their laws or have used general laws, we're now at 69 countries globally, which is up from 59 countries 2 years ago. And on this final slide, before I move over to Michaela's focus specifically on HIV criminalization in Africa, this is where the most recent cases and prosecutions have taken place over the last 2 years. Color-coded, so we looked at the numbers of people diagnosed living with HIV in a country, and then did a calculation per capita of 1,000 diagnosed PL-HIV. And the countries in red have the highest. That's actually Belarus and the Czech Republic. But you'll see even on this continent, a number of countries there have been prosecutions over the last 2 years. And Zimbabwe stands out as the country on this continent with the most number of reported cases. We're aware of 11 over the last 2 years. The US, Russia, Belarus, and Canada are the other countries in the world with high numbers of cases. So with that, I'll pass you over to Michaela, where you'll hear more about the issue of HIV criminalization in Africa. Thank you.